Morning. Hello and welcome. If you are a student curious about how privacy laws are shaping the digital economy, or a professional navigating compliance in your industry, or a business leader responsible for safeguarding user data, this series is for you. In this video series, we'll explore India's landmark Digital Personal Data Protection Act 2023, a transformative law that defines how personal data is collected, stored, used, and protected in a digital era. But we are not just scratching the surface. This is a deep dive across 8 focused parts where we break down the impact of the DPDP Act on some of India's most data driven and compliance sensitive industry, namely the BFSI sector, where consent, risk, reporting rules are redefining how banks and insurers operate. We look at IT service industry where global delivery centers must align with both Indian laws and client expectations. We'll then look at the healthcare sector where patients' rights and sensitive data demand ironclad protection. We look at the hospitality industry, wherein managing trust, identity, and personal preferences of millions of guests is paramount. We'll then look at the educational sector, where children's data is at the center of privacy enforcement. We'll then touch base on the world of marketing and sales, where consent is now the backbone of every outreach strategy. And finally, the social media industry, navigating new restrictions around profiling, tracking, and child safety. So, whether you are preparing for compliance in your organization or simply want to stay informed, this series is designed to simplify the law, contextualize the impact, and guide you through practical next steps. So, grab a cup of coffee, stay tuned, and let's together decode the DPDP Act one sector at a time. Let's now look at the impact on educational sector from a DPDP Act perspective. Now, when we say educational sector, it includes schools, colleges, edtech platforms, tuition centers, digital learning providers, and academic research institutions. In this session, we will cover the introduction, why the education sector is highly affected, roles defined by DPDP Act, core DPDP obligations for the educational institutions, sensitive and risky data in educations, what are those, key challenges for the education sector, specific impact area by segments. We look at strategic opportunity, we look at actionable compliance steps, we look at cross regulation synergies, and then look at DPDP compliance checklist for educational sector. We look at how to implement it and then close off with the conclusions. Starting off, why education sector is highly affected because of DPDP Act? Well, the education ecosystem collects and processes a vast amount of personal and sensitive data, which includes children's identity details, academic performance and behavioral records, health and disability data, family and financial information, photos, videos, biometric logs, location, and device data from online classes. With digital classrooms, edtech apps, and online assessment, this sector is increasingly data driven but often lack structured privacy protocols. Let's look at the roles defined by DPDP Act. The schools, colleges, and universities under DPDP are known as data fiduciaries as they collect data directly from students and parents. The edtech platforms, LMS providers, are categorized as data fiduciaries and processors. This is based on service model and data decisions. The SaaS and cloud service providers are known as or categorized as data processors. They host and process data on behalf of institutions. The large institutions or platforms are known as significant data fiduciaries or SDFs. This is based on the volume, risk, or children's data. Let's now look at the core DPDP obligations for educational institutions. They must obtain clear, informed consent and student parent before collecting the data as per the DPDP Act. It's mandatory for student under 18. They would require a verifiable consent mechanism to be in place. They will only collect what is essential. The student data collected for academics can't be used for marketing or profiling. Students or parents must be able to review and correct the records. That visibility need to be provided to the parents and the students. It's required to delete records when no longer needed or on a legitimate request. The schools and edtech firm must offer a clear privacy compliant channel. They must notify the board and affected individuals within 72 hours in case there is a breach. From a sensitive and risky data perspective, child identity and location are considered sensitive and risky. Any learning difficulties and psychological assessments are also categorized in a similar nature. The other areas are special need accommodation, video and voice recording from online classes, biometric attendance systems, parental income and fee payment data. These are all considered sensitive and risky data in education. This makes education a sensitive and high stakes sector for data protection. Let's now look at key challenges for the education sector. There are strict rules which applies for those under 18 year age. Most institutions serve this age group. Many small medium school lack formal IT security and privacy policies. That's a big challenge from a data governance perspective. The digital aspect of governance is a major challenge here. External platforms collect, store, and analyze students' data. Hence, the challenge is managing your third party edtech integration. There are inadequate mechanisms to verify parental identity or track consent. This was not required earlier, but now with this act, it is mandatory. So, that's a challenge which the edtech sector would need to factor in and build out and think through how they are going to manage it. Institution may ask for unnecessary data like caste, religion, and so on. That would require to stop as per the act. Not relevant. Apps used for class tracking, assessment, and performance scoring can become or can be considered as intrusive. So, a tech firm would need to think through how they are going to manage it off. Now, let's look at specific impact area by segment. From a school and college perspective, they must revise their admission forms, consent slips, and CCTV usage declaration. They would need to enforce parental control mechanism for underage data. They would require to train teachers on handling students' data sensitively. They would require to review attendance and monitoring tools, especially those using biometrics. When it comes to edtech platforms, they need to redesign app permission and onboarding flows to comply with DPDP. They need to ensure opt in only for data tracking, AI based scoring, or learning analytics. They need to review edtech or marketing integration for premium models. They need to establish redressals and withdrawal mechanism in in-app setting. For research institutions, they need to ensure anonymization or specific consent for using student participant data in academic studies. They are required to align research data handling with DPDP plus ICMR or national bioethics policies. They are required to maintain data logs for access and ethical approvals. Now let's look at the strategic opportunity in this. This promotes privacy aware school branding, which would attract modern digital conscious parents. We need to building up DPDP compliant edtech solutions that are export ready. So if you are into development and you have built up a solution on edtech and it is DPDP compliant, it would be more a welcome and can go beyond the boundaries of the country. So it's a product which can be built on. They can have enhanced data ethics awareness in students and faculty through privacy literacy, and a stream in itself which can be developed and imparted to the students, may giving the organization or the institution an edge over others. They can become a privacy benchmark institution and reduce regulatory exposures. Again, a good initiative for the college or the school to show how they are different from others. The next is actionable compliance step. They need to be digitize parental consent, verify source. They need to display at app logins, the privacy notice, admission portals, these select sections and classrooms. The privacy notice would be required to be displayed at all places. The consent need to be taken before starting off the whole process. When it comes to children's data, they need to disable profiling, ad tracking, auto share analytics without opt in. If not opt in, you can't do this. From a vendor management perspective, audit for third party apps, learning platform, and cloud provider would be required. You need to set timelines for deleting attendance logs after 1 year unless needed. Example. The record retention aspect need to be factored in. From a training perspective, you are required to train all staffs on privacy handling, grievance escalation, and breach steps. From a technology control perspective, you need to implement encryption, secure APIs, access logs for learning systems. From a grievous redressal perspective, you need to set up complaint portals for students, parents, where you can track and respond promptly for any grievances. Moving on, from a cross regulation synergy perspective, you have NEP 2020, which is encourages digital learning. DPTP ensures it is safe. So there is an alignment there. When you come to ICMR and UGC research guideline, it can be aligned with data protection and impact assessment. From a COPPA perspective, DPTP strengthens readiness for global compliances. Let's now look at the compliance checklist, which can be used by the organization or the institution to get in compliant with the DPDP Act's requirement. The first aspect is governance and accountability. You need to appoint a privacy compliance officer or a DPO. DPO is mandatory for large institutions or edtech platforms. Then you need to create a privacy committee which should include IT, academic, legal, operations and students welfare team. Then you need to classify the institution or platform as a data fiduciary or a significant data fiduciary based on scale and sensitivity. You need to draft and approve a privacy governance framework which covers your policy, ownership, or oversight, etc. Once this is done, we move to the next part, which is data inventory, flow mapping, and classification. In this, you need to identify all personal and sensitive data collected, which could be student identity, academic record, health disability info, biometric facial attendance, fees or payment details, parents and guardian information. Then you need to map the data flow across admission, classroom, online platform, libraries, hostel, labs, and so on. Then you need to classify data as personal, sensitive personal and children's data. Then we move on to consent and notice mechanism. In this, you need to design and implement consent forms, paper or digital, for students, data collection, for use in competition or events or publication. You need to provide clear multilingual privacy notice at admission portals, mobile apps, digital classroom login, all of these places where you are engaging, you require those in place. The privacy notice, and this should be multilingual based on the location that you operate from. Once this is done, then you move to consent to data principal rights handling. In this, you set up student family self-service portal to view the data, to request correction and to request deletion. You need to define internal workflow for ID verification, internal routing, logging and responding to request. Then you need to enable right to nominate. Example, in case of mental disability or parent unavailability. Once this is done, then you move to the next phase of which is retention, minimization and deletion aspect. In this, you need to establish data retention schedule, which could be academic or CCTV attendance or hostel access record. Then you need to implement data minimization. This is to avoid collecting details which are not required to. Could be PAN, religion, caste, unless necessary or required by any specific law. You need to reduce intrusive questions in forms and surveys. You need to automate data deletion and archival process post graduation or withdrawals. Once this is covered, then we move to security, breach and response planning. In this, you would need to implement baseline security controls, which include securing data at rest and in transit. You need to implement baseline security control for role-based access control, logging and monitoring of staff access to student records. Then you need to draft a data breach response standard operating procedure aligned with DPDP Act and certain. Then you need to simulate breach scenario. Could be misplaced USB, misdirectional email, cloud platform, and so on and so forth. There are various combination of breach scenarios. Once you have covered this, then you move to children's data protection. In this, you would need parental consent for enrollment, app use, exam proctoring, wellness assessment. You need to ensure that you need to disable ad tracking, profiling, behavioral analytics on students under 18. You need to limit the collection of location, voice, video data from children's device. Once this is completely addressed, then we move to the next aspect, which is edtech and digital infrastructure. You would require to review all platforms, whether it is learning management system or LMS, ERP, Zoom, Google Meet integration, pro- proctoring tools. You need to ensure apps and platforms present their privacy policy upfront. Log consent, allow data deletion requests, secure data during transit and in processing, and restrict access to dashboard based on roles, whether it's a teacher or an admin. Post addressing this aspect, we move on to the next one, which is third party and vendor governance. You are required to list all vendors handling student data, whether it is cloud storage provider or online exam tools or cafeteria swipe card systems. You need to sign or update data protection agreement to include data breach terms, consent handling, deletion on contract exit. You need to conduct privacy and security assessment before onboarding the vendors. Once this is addressed, we move to the next, which is research and academic projects. In this, you are required to anonymization or explicit consent for any project using student or family data. You need to ensure research proposals are reviewed for data ethics, logged with data access justification. You need to align with ICMR or UGC research data norms where applicable. Once that's addressed, we move to the next one, which is grievance redressal. In this, you need to set up privacy compliant channels, which includes emails, app portal integration, phone helplines. You need to appoint a grievance officer, which can be combined with the DP, of course. You need to maintain a grievance register with type of complaint, date of receipt, resolution timelines, etc. You need to target the resolution within 30 days as per the best practice or lower. If there are specific guidelines which would come in from DPDP Act, we need to follow that, but let's see whether that's defined. The next phase after this would be from a training and awareness perspective. You need to conduct training for teachers and professors, admin staffs, IT teams. You need to include privacy awareness in staff induction, student orientation. You require to run annual refresher session and awareness drives. Once this is there, you move to the last part in this checklist, which is from monitoring, auditing, and continuous improvement perspective. You need to create compliance dashboard for internal use. You need to schedule annual privacy audits, whether it's internal or third party. You need to maintain record of DPIAs, consent logs, breach history, redressal metrics. You need to track the DPDP rule updates and sectorial guidance from MIT, CBSE board or state board, UGC or AICTE or educational technology committee. This is a complete checklist for the education sector to be in compliance with DPDP. Do note, this is an indicative list. You can build on it. But if you don't have it, this can be a good start point. Align this to your requirement. See what is relevant to your space. How many of these are applicable? It could be all, it could be some, few, or in some cases, maybe it's not at all applicable. You might have a different sort of compliance checklist. Take what's relevant, what's applicable, those applicable, but you cannot implement it at this point of time. Record it off so that it can be declared upfront with a strategy as to how are you going to get it through finally. I hope this checklist helps you with a perspective. This helps you with a trigger point. I hope this helps you build your sector to be compliant with DPDP so that you don't end up having to pay a penalty, which are pretty stringent in this act. Let's take a sector by sector look at how the DPDP Act 2023 impacts different industries. Because compliance isn't one size fit all. I have compiled a comparative table covering BFSI, IT services, healthcare, hospitality, education, marketing and sales, and the social media industry. So let's break it down. Consent management. Well, consent is the cornerstone of DPDP Act, but its implementation varies. In BFSI, consent must be tightly managed, especially for KYC, biometrics, and financial information. In healthcare, it's even more sensitive. Patients and parents' consent is absolutely critical. For marketing and social media, consent isn't just required, it defines whether your outreach is legal or violation. When it comes to children's data, this is where the act is more stringent or most stringent. Educational institutions and social media platforms are directly in the spotlight here. Under DPDP, profiling or targeting anyone under 18 is strictly restricted. And verifiable parent consent becomes non negotiable. Do note, verifiable. The organization need to have a mechanism where it can prove that the parental consent was indeed from the parent. Next, on the data rights enablement perspective, all sectors must now empower users to access, correct, or delete their data. That means banks, schools, hospitals, hotels, and even digital marketers need process and tools to honor these rights, preferably through user friendly portals. When it comes to breach notification, every sector is now bound to notify the Data Protection Board, and in most cases, the affected individual within 72 hours of discovering a breach. In healthcare, this could be patient's record. In hospitality, it could be passport scan. Or for social media, a profile leak or consent compromise could trigger serious reputational and legal consequence. When it comes to third party or vendor risk perspective, here's where the rubber meets the road. Whether you are a bank outsourcing IT, a school using a learning app, or a marketing team working with an agency, the DPDP Act expects you to own the responsibility for your vendor's privacy posture. Data processing agreements and audits are no longer optional, they are essential. When it comes to grievance redressal, the DPDP Act mandates every organizations to have a clear, accessible grievance mechanism. This might look like a chatbot, an email, or an in-app feature. And it's especially critical for social platforms, hotels, and edtech apps that serves diverse digital first users. Well, likelihood of being classified as a significant data fiduciaries? Well, lastly, we assess the SDF risk across sectors. It is high for BFSI, IT, healthcare, and social media because of the sheer volume and sensitivity of data they process. For educational and hospitality, it is medium to high, especially if you are running large networks. And for marketing, if you're handling mass personalization and cross platform tracking, the risk goes up fast. So, as you can see, while the principle of the DPDP Act remains universal, the real world implication differs greatly depending on the sectors. Some industry will need to overhaul their tech infrastructure, while others will need to fix their lead generation or outreach tactics. But for all of us, it's a journey towards being more transparent, ethical, and user centric data practice. In the next part, we'll deep dive into each sector one by one. So stay tuned and don't forget to like, share, and subscribe if you are finding this series helpful. Do note this slide we will come again and again on all the modules that we are going to discuss. So, in case you have missed out or you need to have a better context, so when we look at BFSI and IT services and all the other areas, we will refresh this slide again and the context. In conclusion, compliance with DPDP Act is a legal necessity and a trust building opportunity for the education sector. Institutions that treat students' data with respect and transparency will lead the way in safe, ethical, and responsible digital education. The DPDP Act requires the education sector to modernize its data handling practices, especially when it comes to children and digital learners. Schools, colleges, and edtech providers must treat students' data as sensitive, protected, and consent based, not just operational or administrative. Early adoption of privacy by design and structured governance will boost credibility, reduce risk, and enhance trust. I hope this video has helped you in some form and shape. With this, we'll come to the end of this part wherein we looked at DPDP Act and its impact on the educational sector. We covered the original agenda, and now it's time to move to the next part 7, where we'll touch a new sector and how it has been or it gets impacted due to this DPDP Act and what's required to get in compliance. This is your host Savit Vittal Salian. I'd like to thank you for the time that you invested. If you think this has added value to you and your organization, do like and subscribe. Definitely do share this with someone who you think can benefit, can help build. The idea here is to share as much as possible so that it benefits as many people as there. I'll take a leap for now. Take care. Have a good day. Namaskar.